June 1975. A radio crackled. A nation held its breath. With one announcement, democracy dimmed and dictatorship took root. The emergency wasn't just a political storm. It was a direct assault on the Indian constitution, the courts and the citizen. In our next report, we revisit the verdict that shook the government and the silence that followed.
भाइयों और बहनों, राष्ट्रपति जी ने आपातकाल की घोषणा की है।
This announcement marked the beginning of one of the darkest chapters in India's democratic history, a time of unprecedented repression. But what triggered it was a judicial verdict from the Allahabad High Court and the Supreme Court's refusal to fully stay that order. On June 12, 1975, Justice Jagmohan Lal Sinha of the Allahabad High Court delivered a landmark judgment declaring then Prime Minister Indira Gandhi's 1971 election from the Raebareli constituency null and void due to electoral malpractices. Indira Gandhi appealed to the Supreme Court, where Justice V.R. Krishna Iyer refused to grant a full stay on the High Court's ruling on June 24, 1975. The very next day, the emergency was imposed. What followed was an era of authoritarianism, and democracy in India was pushed to the brink. Fundamental rights guaranteed, equality before law, right to life and personal liberty were suspended immediately after the declaration. By January 1976, Article 19 was also suspended, effectively snatching away the rights of free speech, press, association and peaceful assembly. As the machinery of state suppression kicked in, the judiciary wasn't spared either. Lawyers who dared to speak out in defense of civil liberties were arrested. In March 1976, without any prior notice, 200 chambers of practicing lawyers at Delhi's Tisazari court were demolished, and 43 lawyers were sent to jail. Soon, attention turned to High Court judges who had passed verdicts against the government's excesses. Many were transferred or faced punitive action for their rulings. But the most prominent casualty of judicial independence during the emergency was Justice H.R. Khanna. He was the senior-most judge in the Supreme Court and the natural successor to become the Chief Justice of India. But in the ADM Jabalpur case, where the core issue was the suspension of fundamental rights during emergency, Justice Khanna stood alone in dissent.
जो आतंक का माहौल था उसमें जजों को इतना ज़बरदस्त डराया गया। एन रे का केस पहले से ही चल रहा था, यानी 7-8 जजों को सुपरसीड करके जो एन रे को चीफ जस्टिस बनाया था, तो ऐसे भी जुडिशरी डरी हुई थी। तो जबलपुर का एक केस है जिसमें जीने का अधिकार भी जुडिशरी के माध्यम से इंदिरा गांधी सरकार ने नागरिकों से छीन लिया था।
His principled stand cost him dearly. The Indira Gandhi government superseded him and appointed a junior judge, Justice Mirza Hamidullah Beg, as the Chief Justice instead. In protest, Justice Khanna resigned the very same day.
Justice Khanna यह स्वीकार करने के लिए तैयार नहीं थे कि किसी भी हालत में सरकार द्वारा किसी नागरिक से उसके जीने का हक और अदालत में न्याय मांगने का अधिकार यह छीन लिया गया। अपने डिसेंटिंग जजमेंट के लिए जस्टिस खन्ना को क्या कीमत चुकानी पड़ी है, यह बात भारतीय लोकतंत्र के सबसे काले अध्याय के पन्नों में अंकित है।
Indira Gandhi's authoritarian grip extended to the constitution itself, which she amended multiple times during the emergency to consolidate her power. The 38th Amendment took away the judiciary's power to review the emergency. The 39th Amendment barred courts from questioning the election of the Prime Minister altogether. But the most alarming was the 42nd Amendment, often called the Mini-Constitution, which altered 40 different provisions of the Constitution under Article 368. In independent India's 75-year constitutional history, this remains the only amendment that even changed the preamble of the Constitution. The very soul of the Constitution was suffocated during the emergency. Bureau Report, DD India.